Good evening, everybody. Today I will discuss about Section 41A of CRBC, which was aimed to avoid unnecessary arrest or its threat of being arrested, looming large on the accused, which required to be addressed. Section 41A was inserted in the Code of Criminal Procedure by Amendment Act of 2008. However, after the enactment of said amendment, various representations were received by the Union government and some specific amendments were brought in the Code of Criminal Procedure White Amendment Act of 2010. The earlier subsection 1 of section 41A states that the police officer may, the word to be noted, there was mention of may. In all cases where the arrest of a person is not required under the provision of subsection 1 of section 41, should issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. The amendment of 2010 ensured that a police officer issues such notice by substituting shall in place of may by section 3A of the 2000 Amendment Act. The Amendment Act also enacted a provision to section 41B subclause to providing for recording of reasons for not arresting an accused. And now I will read amendment so that we will be able to understand completely. Section 41A starts with the heading Notice of Appearance before Police Officer. The police officer shall, in all cases where the arrest of a person is not required under the provision of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. So the only difference between both the amendments is only may and shall. Earlier it was may and now it is shall. It has been made compulsory to issue a notice. We all know that up to 7 years, this provision required to be put into operation. Where the punishment for the offence is up to 7 years, then the notice under section 41A is mandatory. Where such a notice is issued to any person so-called accused in the crime, it shall be the duty of the person to comply with the term of the notice. Where such person complies and continue to comply the notice, he shall not be arrested in respect of the offence referred to in the notice unless for reason to be recorded. The police officer is of the opinion that he ought to be arrested. Where such person at any time fails to comply with the terms of a notice or is unwilling to identify himself, the police officer may, subject to such order, may have been passed by the competent court in this behalf, arrest him for the offences mentioned in the notice. Now, earlier there was discretion in arrest, and it still exists. And now I will discuss what are the effects of this discretion. First, going by the Definition of discretion. It is the ability of the authority to choose amongst various available alternatives without reference to any predetermined criteria. There is no criteria to define discretion. It is the, you can say, various alternatives which are available to the authority to use it wisely and judicially. But the things are some different when the police officers do so. He may be having alliance with one party or maybe with the other. So he may do it in its own way. No matter how fanciful the choice may be, where the term arrest implies the act of taking into custody of another person under the authority of law for the purpose of holding or detaining him to answer a criminal charge and preventing the commission of an offense, it results into a temporary strain on the exercise of some of the fundamental rights by the accused. We are all know that arrest is arrest. However, apart from legal mechanism concerning the arrest, there is a psychological effect of the arrest as well. The arrest adversely affects the social life and the future prospects of the person arrested and leads to an irreparable loss of his public image. Our Honorable Delhi Court, in the case of Rakesh Kumar versus Vijayanta Arya, DCP, and others, had observed and pointed that it is not only the accused who suffers the humiliation and indignity of being arrested, rather, the effect of this is on the reputation of his whole family. No amount of explanation to the neighbors or those who have seen the arrest would undo the embarrassment and indignity suffered by the accused and his relatives. Arrest and incarnation destroy a person and affects many other innocent relatives. Subsequent release or acquittal of innocent is of no solace and offers no reparation to the loss of reputation or for the temporary loss of precious personal liberty. A stigma gets attached to the person who has been taken away, detained, or put behind bars by the police. Therefore, considering the above facts highlighted in the judgment, it became imperative for the authorities to be cautious and use utmost prudence while exercising discretionary power of arrest as defined under Section 41 and 41A of the Code of Criminal Procedure, which can be attributed to the terms like reasonable complaint, credible information, and reasonable suspicion, not the normal information which is not reasonable, one should be arrested. These terms open an array of subjective satisfaction of police authorities being proceeding further. It is obligatory for the police officer to record the reasons as per provision of section 41A subclause 3. What it says that where such person complies and continues to comply with the notice, he shall not be arrested in respect of offense referred to in the notice, unless for reason to be recorded, the police officer is of the opinion that he ought to be arrested. To take steps to avoid unnecessary steps, the judiciary came forward, and I am discussing a few of the court judgment which has controlled this situation. Firstly, Supreme Court issued guidelines in the case of Amesh Kumar versus State of Bihar, 2014, 8 SAC 273 to prevent the abuse of discretion and harassment by the police in a case involving the application of Section 41 of CRPC. The guidelines are as follows. All the state governments to instruct its police officers not to automatically arrest when a case under Section 498 IPC or Section 4 of the Dowry Prohibition Act 1961. These two acts are most widely abused by our society. But also such other cases where offence is punishable with an imprisonment for a term which may be less than 7 years. He should follow the necessity for arrest parameters under so-called 41A amendment. Secondly, all police officers be provided with a checklist containing specified subclasses under section 41 subclass 1B further subclass 2 of the CRPC. Thirdly, the Supreme Court said that the police officer shall forward the checklist duly filled and furnish the reason and material which necessitated the arrest while forwarding producing the accused before the magistrate for further detention. It was also put duty of the magistrate that while authorizing detention of the accused, he shall personally produce the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. If he is not satisfied with detention, he should release the person immediately. Fifth one was the decision not to arrest an accused be forwarded to the magistrate within 2 weeks. The time is of 2 weeks from the date of institution of the case with a copy to the magistrate which may be extended by the SP of the district for reason to be recorded in writing. If this 2 weeks time is to be further extended, then with the permission of SP. Otherwise, he will have to forward the report to the magistrate within 2 weeks. Notice of appearance in terms of 41 ACRPC, which served on the accused again within 2 weeks from the date of institution of the case, which may be extended by SP of the district for reason to be recorded in writing. Further, the court held that failure to comply with the direction aforesaid shall, apart from rendering the police officer concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. Authorizing detention without recording reason by the judicial magistrate may also be put into trouble and shall be liable to departmental action by the appropriate High Court. Again, the guideline issued by the High Courts for moving procedural drawbacks. In April 2018, Acting Chief Justice of Delhi High Court, Justice Geeta Mittal, in the case of Amandeep Singh Johal versus State of NCT of Delhi and others, issued an detailed guidelines for a notice of appearance before the police officer under Section 41A of the Criminal Procedure Code in order to ensure transparency in the system. The guidelines were as the suspect accused on formally receiving a notice under Section 41A CRPC and appearing before the concerned officer for investigation, interrogation at the police station may request the concerned IO for an acknowledgement. He can ask for the certificate of attendance. Please give me the certificate. I have appeared as per notice. So that later on IO may not misquote that he had not appeared. Even second, you can say, guideline was in the event the suspect accused is directed to appear a place other than the police station, the suspect will be at liberty to get the acknowledgement receipt attested by an independent witness if available at the spot, in addition to getting the same receipt from the concerned IU. Third one was a duly indexed booklet containing serial number in duplicate carbon copy format should be issued by the SHO to the investigating officer. The notice essentially contains the serial number, case number, date, time of appearance, consequences in the event of failure to comply with acknowledgement slip. All were directions were there. The investigating officer shall follow the following procedure. What he will do, the original will serve on the accused. Carbon copy is retained by the IO in his case diary, which can be shown to the concerned magistrate and when required. And when the booklet is used complete, then used booklet are to be returned to the SHO of the police station, who shall retain the same till the completion of the investigation and submission of the final report under section 173 subclause 2 of the CRPC. The police department shall frame appropriate rules for the preservation and destruction of these books. High Court bench also directed that procedure shall also apply to the working of Section 91, 160, 175 of the Criminal Procedure Code. High Court further directed the guidelines shall be widely publicized to ensure that the general public is apprised of the said procedure. Also, in similar matter, the Jharkhand High Court, through its order in the case of Mahesh Kumar Chaudhary versus State of Jharkhand, has asked the State of Jharkhand to consider framing appropriate guidelines regarding Section 41A of the CRPC, so that police may be referred to as the model police. Now, coming to recent trend, how the courts are controlling whether the police officer is using 41A provision or misutilizing it. The Allahabad High Court, in the case of Chandra Kumar, held the investigating officer guilty of contempt for willfully bypassing the guideline laid down by the Supreme Court in the case of Amesh Kumar versus State of Bihar 2014 and sentenced him to simple imprisonment for 14 days. In this case, the court concluded that this all arrest was done due to some under the table things and bypassing the guideline laid down in the Arnesh Kumar case. In a similar manner, the Honorable Delhi Court in the case of Rakesh Kumar versus Vijayanta Arya, DCP, sentenced an police officer to 1 day imprisonment for arresting a person for defying the Arnesh Kumar guidelines. The person concerned was accused for criminal breach of trust, for which maximum punishment was of 3 years. Thus, in accordance with the provision laid down with under Section 41A, he was required to be served with notice, which he avoided. However, the court noted that though notice was served to the accused, that the law was breached. Now, impact of not arresting the accused. It is obligatory for the police office to record reasons based on preliminary inquiry in case he proceeds with the arrest under Section 41A3 of the CRPC for offences with imprisonment for a term which may be less than 7 years or which may extend up to 7 years with fine or without fine. Though this provision on one hand has been instrumental in preventing the unnecessary harassment of the accused in false cases on the name of preliminary inquiry, like in the cases pertaining to Section 498 of IPC and other related offences. However, on the other side, there are many instances wherein the relief from arrest granted to the accused has led to certain repercussions. Though the accused may not prima facie appear to harm the victim on being released or tamper with evidence, this has been seen in from the lower strata of the society that it can be inferred that the mechanical interpretation of the provision may not serve the purpose of granting the safety, thereby diminishing the fear installed in the mind of victims and witnesses. However, there need to be some deterrent effect as well. From the above discussion, on various judgments and bare reading of the provision, it is established that issuing a notice in all cases where arrest is not required to be made under Clause B of Section 1 of the Amended Act 41 is mandatory, compulsory for the police officer to comply with. The unwillingness of the person who has not been arrested to identify himself or to whom notice has been issued could be ground for his arrest. Also, the courts have come down with various parameters granted in Article 21 of the Constitution. We have also seen the cases where contemners being member of the disciplined force in exercise of their power of arrest have willfully and deliberately bypassed the mandate of Supreme Court in Amesh Kumar, which is binding on all the authorities, including magistrate, in view of the Article 141 of the Constitution of India. It was observed that direction contained in the Amish Kumar judgment and the provision contained in Section 41A of the CRC were not being properly worked by local police station and officers, but also that the direction contained in the circular by themselves are wholly insufficient to ensure protection of the rights of persons who are called for inquiry or are subject matter of criminal investigation. Thus, in order to secure public respect and confidence in the judicial process. It was prerogative for the courts to come up with a best set of guidelines, and government shall ensure that effective publicity be given to ensure that the public and authorities are apprised of the procedure which has to be followed for the compliance of the various provisions contained therein. So this is all about section 41A of the CRPC. Thank you for watching with the request that please like, share, and subscribe to my channel so that I may go on doing this service for you all. Thank you.